Well, in this module, we're looking at keeping secrets, confidentiality and sources. And this is the mysterious world of investigative, undercover journalism, sometimes involving international espionage and authorities chasing journalists or bloggers across borders because of their breaches of security. It's the sort of thing that movies have been made about. But nevertheless, it also involves the working journalist, lawyer, and public relations practitioner at a daily, normal level. Because journalists are always taking sources into their confidence. And the reverse happens with those sources taking journalists into their confidence. And there is this flip side to the area of secrets and confidentiality. On the one hand, journalists promise secrecy to some sources for information. And I might say they shouldn't do that too lightly. But on the other hand, journalists are also in the business of telling other people's secrets. So in some contexts, they want to keep secrets to themselves, the identity of their sources particularly, and in other circumstances, they want to find out secret things about other people or things they've done, documents that they've written and so on, and publish them for all the world to see. Now, the way it affects journalists is fairly clear with this confidentiality of sources and them dealing in confidential documents. How might it affect lawyers? Well, law students in their studies do learn about lawyer-client confidentiality, and they also learn about certain obligations that they have as lawyers to the court system, not to release certain information, to be circumspect about communications related to materials that are in confidence, particularly if they're related to closed court proceedings and so on. Now, often these are things that journalists want to know about. From time to time, lawyers have also been journalists' sources and have released information and faced prosecution for the release of that information secretly. For PR practitioners, part of their job is to keep confidential material that could be damaging to their client or to the corporation or organisation that they work for. But on the other hand, public relations practitioners also need a close working relationship with journalists. And sometimes they do give them little tidbits of confidential information to keep them as good contacts in their work. But also, in extreme circumstances, public relations practitioners have seen some wrongdoing in their organisation and have decided to become whistleblowers, blow the whistle on that, and sometimes they've done this through their journalism contacts. Now, we hear a lot in the news about the international espionage aspect of confidentiality and secrets. And over the years, we've had major document releases. In the past couple of decades, a lot of those have come from the organisation WikiLeaks, founded by the Australian Julian Assange. We've also had the former NSA employee, Edward Snowden, who escaped to Russia after releasing a swathe of important national security information about the operations and of surveillance operations of US security agencies. And we've also had Australian journalists join with international media syndicates for the release of what was called the Panama Papers, which were swathes of computer files and documents related to how secret bank accounts throughout the world were sometimes hidden by governments, sometimes involved senior government and celebrity personnel in major international tax avoidance schemes. And they're just some of the examples. Undoubtedly more will unfold during the course where you're studying media law. The area of keeping secrets in one way relates to journalists and the area of contempt of court that we learned about earlier in the course. Now, the textbook talks about this important area of contempt, which is known as disobedience contempt. Disobedience contempt is where somebody interferes with the administration of justice by disobeying some order of the court. And where this can relate to journalists, and where journalists have gone to jail in Australia in recent decades, has been where journalists have disobeyed a court order to reveal their confidential sources in the courtroom. Now, the Journalists' Code of Ethics requires journalists to keep any confidences that they enter into. So it's an ethical obligation on journalists, just as it is on lawyers and public relations practitioners. But the courts recognise at a much higher level lawyer-client confidentiality, for example, than they do journalist-source confidentiality. And so that's how we've gotten into these situations where in important legal cases, judges have finished up ordering the journalists to reveal their sources. Now, there are some protections available to journalists in those situations. Now, the basic law is that journalists are only required to reveal their confidential source if the judge decides that this is relevant, the question that they've been asked is relevant and necessary in the interests of justice. Now, that's the basic law, but it's been extended further in some jurisdictions, including some Australian states and at Commonwealth level, to have what's called a shield law, which is actually a piece of legislation where journalists' rights to refuse to reveal their source are protected under the law, but with some very serious provisos and exemptions. Effectively, the courts are entering into a balancing process. What has to happen is that the judge in these cases, I might say the law varies somewhat between different states, and it varies a lot in the US, where their different states have shield laws, and several journalists have been jailed despite the shield laws for refusing to reveal their sources. But where they exist, they normally involve, firstly, the court identifying that the person is actually a journalist, and that requires the legislation to have some definition of what is a journalist, which does vary a little bit, particularly as to whether news bloggers are counted as journalists. But then the legislation typically requires the judge and the court to enter into a balancing process. And they need to balance whether the public interest in the journalist answering this particular question in this particular case outweighs the public interest in these sorts of confidences being preserved in society. So they have to go into this balancing process. And what we're finding is that in some of the cases, the courts are finding in favour of the journalists, and we suspect this is because the case is not so severe and the question is not so central to the proceedings that it is absolutely necessary, and therefore the confidentiality aspect outweighs the importance of the question to the court. It's relatively early days for these shield laws, so it will be interesting to see how they unfold in coming years. Journalists also have a small element of protection through what the textbook describes as the newspaper rule, which is really just a judge's discretion in defamation cases. In the very early preliminary parts of a defamation trial, the judge has a discretion to not order a journalist to answer a question about a confidential source, because the courts want to stop these preliminary proceedings being activated in defamation simply as what they call a fishing expedition to try to find out the whistleblowers and leaks within their organisation who have given the information to the journalists. So it's really a device to stop defamation being used as a vehicle just to find out confidential sources. But it is used in a fairly haphazard and unpredictable way, so journalists can't rely on the newspaper rule. A related area is the area of contempt of Parliament, and this is to do with parliamentary secrets, particularly of parliamentary committees. Now, you might have a close look at that. At a Commonwealth level, this has been made a lot more lenient for journalists in recent years, but at state and territory level, it is still a worry for journalists reporting, say, on committee proceedings of the Parliament, and prematurely releasing a committee's document or finding when it hasn't yet been publicly released and is still confidential. And that can be found in contempt of the Parliament. So have a close read there. Now, the flip side of journalists wanting to keep a confidence of a source is when journalists get sued under the action of breach of confidence for revealing other people's secrets, which has caused some damage to that other person or company. And that's the action of breach of confidence. And the textbook explains that there's a 3-point test to breach of confidence. Firstly, the information or material must have some quality of confidence about that. And courts will look normally at whether it's reasonable that people would think that it did have that quality of confidence about it. Several factors there explained in the text. The second thing is the circumstances in which the confidential information has been given to the journalist. And it needs to have what's called a confidential situation where the journalists get this information. The documents that suddenly appear mysteriously in their pigeonhole at their workplace, or perhaps the computer file that arrives secretly in the mail, or just someone whispering to them that they have some confidential information. They are the circumstances in which it's imparted. And the third test is whether the journalist has then gone and released this information or proposes to release the information to the detriment of the person who wants that secret kept. Now, we can imagine all sorts of information that can be confidential. It can be to do with people's private lives, their commercial operations. Government information requires the government to prove that it's in the public interest that the information be kept secret, so the onus or the burden of proof switches with government information back onto the government. And there are some defences which are actually, there aren't that many defences journalists can argue to breach of confidence, but the key remedies that the courts will offer can be financial in the form of damages, but they can also be, the remedies can be an injunction where the information hasn't yet been published, and they can issue an injunction to stop the media organisation publishing this secret information. So there you have that module based around keeping secrets, confidentiality and sources. Don't forget, of course, this has been a very broad brush introduction to it. There are many finer aspects beyond this mini lecture that you'll find in your other learning resources. So please have another look at that study plan and work through each of the activities to deepen your learning of the topic area.